Welcome to the webinar session on corporate governance framework for companies versus LLP and its relevance in deciding the suitable entity for one's business. In today's session, we are going to give you a quick overview of the key differences between a private limited company and an LLP, followed by the minimum corporate governance standards that they must adhere to, and what are the practical challenges that may arise in the process. We will then discuss some of the important clauses that must find a place in the LLP agreement to safeguard the interest of its partners against any potential contingencies. Lastly, we will touch upon a few other criteria under the Indian law that may help businesses decide the suitable entity for their business. Before we move on with the presentations, let me just say that during the presentation, please feel free to send in your questions that you may have in the chat window option available, and we will try to address them as part of our presentation to the extent possible then itself. Otherwise, we will take those up separately at the end of our presentation. And one quick clarification I also wanted to give is in today's session, our focus would mainly be on the corporate governance aspects of companies and LLPs, and we would not be touching upon the tax aspects of those. For tax, we will be conducting separate sessions during the course of next week. So please feel free to join those. Now, moving on to the topic in hand, the process of doing business in India can be divided into two buckets broadly. One is where a business is owned by the domestic entrepreneurs, or second, where a foreign investor is trying to start a business in India. In both cases, it is important that the businesses incorporate a legal entity that could not only be the front for the business, but also protect the shareholders or the partners in case of LLP against the risk of unlimited liability that may arise due to any loss or failure in the business. Hence comes the concept of limited liability for doing those businesses. One way to describe limited liability is your risk is limited to your investment. In other words, limited liability is a way to make sure that a person who is engaging in business does not risk his or her personal possessions in case the business fails. In India, the most popular forms of business entities that offer limited liability protection to the shareholders are a company or a limited liability partnership. Each of these entities has its own advantages and drawbacks, but both these models offer its owners the limited liability protection. Now, to understand further on how these entities differ from each other, let me ask my colleague Ankit to take us through the differences between these two forms of legal entities. Ankit, over to you.
Thank you, Prashant. A warm good evening to everyone. The company form of structure is traditional and has been there since many years. But the LLP is a modern form of business structure introduced for the first time in India in the year 2008 with the objective to provide flexibility to entrepreneurs to operate as a traditional partnership, at the same time also providing the benefits of a corporate form. This type of structure has been successfully implemented in various countries. So now, moving forward, let's go through some of the differences between a private limited company and an LLP. We'll start off with the meaning. What do you mean by a private limited company? Private limited company is an entity in which the shares are closely held by a group of people or by group entities. Private limited company requires minimum of 2 shareholders and 2 directors, one of whom should be a resident director. It also restricts or prohibits 3 key aspects in the Articles of Association, and they are: restriction on a number of members is limited to 200, which excludes your current employees and former employees who holds the share. It also restricts transfer of shares, and it also restricts offering securities to the public. Moving on, what do you mean by an LLP? LLP is defined as partnership form and registered under the LLP Act. It is an alternative corporate structure that gives the benefit of limited liability of a company and the flexibility of a partnership. LLP can continue its existence even if there is change in the partners. It It can enter into contracts. It can also hold property in its name since it enjoys the benefit of a separate legal entity. Moving on, we will discuss on what are the governing laws for both private limited company and LLP. Private limited company is governed by Companies Act 2013 and the rules made thereunder, FEMA, Income Tax Act, and any other statute depending on the business in which the private limited company is engaged into. On the other hand, LLP is primarily governed by the LLP Act 2008 and the rules framed thereunder. FEMA, the Income Tax Act, and any other statute wherein the LLP wherein the LLP is basically conducting its business into. The third point is with relation to the liability of the entities. So for a private company, if there is any liability which is arising out of the operations of the private limited company, then it has to be purely borne by the private company itself. The liability of the shareholders is only to the extent of the unpaid share capital, unless the liability occurs due to some wrongful act or omission of the shareholder. Now, moving on with the liabilities of directors, there are several provisions in Companies Act wherein the directors are the first person to be in line to be held responsible for any defaults. The directors may also accrue various liabilities under various statutes that the companies entered into. As the directors hold fiduciary position, as directors hold fiduciary position, they also become vicariously liable for the acts of the private limited company or other directors also. Now, in case of an LLP, if there is any liability arising out of the operations that is to be borne by the LLP out of the assets, the partners are liable to the extent of their capital contribution and as per the terms mentioned in the LLP agreement. In case of absence of the partnership agreement, we can refer to Schedule 1 of the LLP Act. Now, moving forward, we refer to the criteria to set up a private limited company in LLP. Private limited company requires minimum of 2 shareholders or 2 directors. The shareholders can be a natural person or a body corporate, but the directors are required to be an individuals, one of whom should be a resident director. Similarly, in case of an LLP, there are requirement of 2 partners and 2 designated partners. The partners can be again a natural person or a body corporate, but the designated partner should be an individual and who should be a resident. Now we'll move on to the compliance related differences. The first one is the frequency of the meeting and other related compliances. As you are aware, in the Companies Act, there are specific sections which directs the company to hold at least 4 board meetings in a year and also conduct the AGM within the specified timelines. It also prescribes certain provisions with or certain compliances with respect to circulation of notices, draft minutes, signed minutes to all the directors, etc. When you consider in case of an LLP, it is purely governed by the LLP agreement, and there is no specific provisions in the LLP Act. Moving on, with respect to filings with ROC. As you may be aware, in case of a private limited company, most of the corporate actions are required to be filed with the ROC. In case of an LLP, there is no such requirement. There are minimal filings to be done in case of an LLP. Third point will be on the statutory auditors. In case of a private company, there is a mandatory requirement that the auditors are appointed for a specified time period. And there are also provisions which tells you if there is any casual vacancy, how to deal with that situation. But in case of an LLP, statutory auditors are to be appointed only in case the LLP crosses certain thresholds. The first one being if the LLP's turnover crosses 40 lakhs, and the second one would be when the partner's contribution exceeds 25 lakhs. Then only the audit of financial statements become applicable, by virtue of which statutory auditors have to be appointed. Now, The fourth point is difference in ownership and management. There is a clear distinction in case of a private limited company between who are the owners and who will be responsible for the management. The shareholders are the basic owners of the company, whereas directors are responsible for day-to-day operations and the management of the company. In case of an LLP, the partners have to play a dual role, and there is no clear distinction on who will be the owner and who will be handling the management part. Further is regarding the additional disclosures. Additional disclosures in case of a private company means the CSR spending disclosure, whether SBO is applicable or not, whether MSME payments have been done or not. All such provisions are to be additionally disclosed in case of a private company, whereas in case of LLP, no such requirement is there. Now, moving on is the dividend distribution tax point. Now, this has got amended recently as per the Finance Act 2020. Earlier, when a company used to declare dividend, as per Income Tax Act, they had to pay dividend distribution tax to the tune of 20 odd percent, and thereafter it wouldn't be taxable in the hands of the shareholders. In case of an LLP, but this has been done away with as per the Finance Act 2020, and the company is not liable to pay dividend distribution tax. The tax has to be borne by the recipient of the dividend on or after 1st April 2020. Now, so to conclude, if you have to select a particular organization structure, it has its own advantages and disadvantages. It also depends on the intent of the entrepreneur, what is his objective, and what is the risk-taking capacity, the cost involved in it. All these factors have to be considered, and then he can decide on which structure is suitable for the business. Thank you, and I request Prashant to take over.
Thank you, Ankit. I think before we move on, there are a couple of questions that have come in, which may relate to some of the topics that you covered. So maybe would you like to answer those before we move on? I think there are a series of questions that have come from Divyang, and these are like, just give me 1 second. Would there be a LLP where there is only one partner that holds 100% shares in the profit or loss? So maybe if you can just answer that. I mean, my understanding is that you at least have to have a minimum of 2 partners to set up a LLP, but maybe you can second that.
Yep. Yes, Prashant, your understanding is correct. The LLP Act clearly mentions that there should be at least 2 partners, and there cannot be one partner holding 100% of the capital.
Then there's another question from Divyang itself. It says that can there be a reduction of contribution of partners of the LLP? If so, what is the compliance for this? I think my understanding here is when you say reduction of capital, you mean amending the LLP agreement wherein you are agreeing for the contribution amount to be reduced. I think by way of amending the LLP agreement, that is a possibility, and all the compliances in that case would have to be similar to the compliance that you follow in case where you have to amend your LLP agreement for any other reason, which would require you to do that filing with the ROC. Along with the information that is required to be provided. Is that correct?
Prashant, so just to add there, hi Ashish here. Basically, when you say reduction of contribution of partners, it could also mean that you are taking out the money that they are basically paid as capital, which could be somewhere like retirement of sorts, and that also could be one interpretation that could be taken.
I think then there are some other questions with respect to can there be ROFR or preemption rights with respect to transfer of capital contribution. I think this is something we'll cover when we'll discuss some of the important clauses under the LP agreement, and then maybe Santosh can take this up later. So we'll now move on. So now in the context of limiting one's liability, it is important to understand that in order to offer limited liability or protection or to offer full protection against any liability arising due to the actions of the company or the LLP, businesses must properly conduct their affairs as well. So it cannot be that they have registered their entity as a private limited company or an LLP, and by virtue of that, they are now eligible for limited liability, but they keep conducting their business in a manner as if it is attributable to the person who is conducting this business, and it could be related to that. In those cases, it is possible that if a claim arises, then the courts may pass an adverse order, and the liability could still be established in those cases. And this could be done by way of lifting the corporate wheel, and there is still room. So that is where it becomes very important that the conduct of the company should be well intact, and for doing that, the corporate governance standards of the entity should be very robust. On that note, let me put a question to my colleague Maulin. Maulin, once we have these entities in place, be it a company or an LLP, and when it commences its business, how important is for a legal entity to adopt the right set of corporate governance standards? And what are the minimum corporate governance standards that they must adhere to under their respective laws?
Thank you, Prashant. So, over the years, India has seen some of the biggest ever corporate frauds and governance failures, such as Satyam Computers, Harshad Mehta fraud, Kingfisher Airlines, Ranbaxy, Waters, PNB scam. With this, the concerns about good corporate governance have increased remarkably. Even internationally, there has been a great deal of debate going on for quite some time. The famous Cadbury Committee defined corporate governance in its report in the year 1992 as the systems by which companies are directed and controlled. So we need to understand that the spotlight is on both the large as well as small corporates as to how prudent they are in following corporate governance standards. Many believe that only companies with independent directors, having top level management, and with large group of shareholders needs to be concerned about or can benefit from by implementing corporate governance practices. However, in truth, it is pertinent that all entities, big or small, private or public, requires good governance. This belief that corporate governance applies only to companies and not to any other form of entity such as LLP, to my mind, is incorrect. But before going ahead with our discussion on the need for corporate governance, we need to understand the concept of corporate governance. Broadly, the term corporate governance describes the processes, practices, and structures through which an entity manages its business affairs and at the same time work towards meeting its financial, operational, and strategic objectives and achieving long-term sustainability. The concept of corporate governance can be described as a set of principles, rules, regulations, systems, processes, laws governing a corporation. It is important that a corporation is fair in its dealing and transparent to its stakeholders at large. The need for corporate governance has arisen because of increasing concerns regarding the non-compliance, non-disclosures, standards of financial reporting, and accountability, followed by board of directors and the managerial personnel, inflicting heavy losses on the investors. Therefore, let's go through a few points which showcases the importance and need for corporate governance. Foremost, first and the foremost point is that it ensures corporate success and economic growth. It helps in forming a good brand regarding the company. It lowers the capital cost. There is a positive impact on the share price. You try to run the business more ethically. It minimizes corruption, risk, and mismanagement. So, coming to the question on framework of corporate governance in companies. Now, the Indian statutory framework has by and large been in consonance with the international best practices of corporate governance. Broadly speaking, the corporate governance mechanism for companies in India is enumerated by certain enactments, regulations, guidelines, listing agreement, such as the Companies Act and rules framed thereunder. Amongst other things, it contains provisions relating to composition of board, including for independent directors, frequency of meetings, composition of various committees and their meetings, accountability for disclosures, evaluation and qualification process, so on and so forth. Then there are rules, regulations, and guidelines issued by SEBI, which has jurisdiction over listed companies to ensure protection for investors. Then we have listing agreement with stock exchanges. Then there are different accounting standards issued by the Institute of Chartered Accountants of India. There are secretarial standards issued by the Institute of Company Secretaries of India. Now, amongst all these things, These regulations lays down several duties, responsibilities, and liabilities on directors. And they are required to act in the best interest of the company in the broadest sense. For the Companies Act also casts responsibility on the directors to devise proper system to ensure compliance with the provisions of all applicable laws. Thus, this doesn't restrict the compliance requirement only to the provisions of Companies Act. It is also applicable to all other laws such as labor laws, tax laws, economic laws, IT laws, sector and business specific laws. Now, coming to LLPs, a question that we generally come across is whether the concept of corporate governance is only limited to companies. In India, businesses mainly operate as either companies or LLPs or sole proprietorship or partnership firm, each subject to different regulatory and tax regimes. However, one of the most preferred and popular choice of entity for doing business nowadays is an LLP. It's an alternative form of business organization. It not only provides the benefits of a limited liability, but also allows its member the flexibility of organizing their internal affairs as a partnership based on a mutually arrived agreement. The ease of doing business coupled with limited liability of a partner and fewer compliances are three of the most important factors which people look at while choosing the LLP model for their business. Unlike a partner under the Indian Partnership Act, a partner under LLP is not responsible for any independent and unauthorized act of other partners. In an LLP, individual partners are shielded from the joint liability created by another partner's wrongful act and misconduct. However, if we see, none of the regulations, including the LLP Act, have a robust framework of corporate governance for LLPs. Unlike in the case of companies where there are detailed rules, regulations covered under the Companies Act, or sectoral standards, and various regulations and circulars issued by SEBI, for certain listed entities, there is no specific standard rules or recommendations given under the LLP Act or by any regulatory body where it specifically details the governance practice to be followed by an LLP. Thus, for better governance in LLPs, firstly, it is advisable that even the designated partner's approval is required for certain businesses which can be agreed in the agreement. As we all know, while the compliance responsibility falls on the shoulders of a designated partner, the decision-making power are in the hands of a partner. Thus, there is a need to have a proper balance of power and responsibility to ensure effective corporate governance. Secondly, extra powers or rights should be given to the partners, who have substantial contribution in the LLP for certain corporate actions. We generally term it as reserved matters. For example, specific authority of partners holding majority stake may be required for borrowings, making investments, or giving guarantees, or at the time of entering into any transaction with related parties, above certain limits. Just like in case of companies, it is important that even LLPs conducting meetings periodically and maintain the recordings of such meetings in form of minutes. The rationale for such compliance is to spread good governance discipline and ensure even LLP adopt uniform practice in convening meetings, having agenda items which would be placed before the partners, etc. This would also help the LLP to create records of the decision taken and also provide adequate disclosures to all the stakeholders. Also, certain concepts such as beneficial owner, registered owner, ultimate significant beneficial owner, corporate social responsibility, having certain policies and registers in place, etc., which are already there in the Companies Act, can be extended to LLPs as well. We now understand that even MCA is looking to amend the LLP Act along the lines of Companies Act, as the regulations governing LLPs are less stringent in comparison to those governing companies. And it provides scope for people to carry out certain illicit activities under the LLPs. Currently, LLPs are not bound to comply with accounting standards, and the ROC also does not have any power to inspect their operations. Thus, we expect the amendments to be soon in place and prepare ourselves to welcome the corporate governance framework in LLP as well. Last thing that I would like to say is that the concept of corporate governance is not an end. It's just a beginning towards growth of the company for long-term prosperity. Over to you, Prashant.
Thank you, Maulin. Thank you for the detailed information on the various safeguards that are there in the form of corporate governance. Now, with that, I would now like to move on to Chandrashekar to get his thoughts on some of the practical challenges that may arise while adhering to these corporate governance standards, and what are the possible ways how those can be tackled. I mean, considering there are some fundamental differences between the governance framework for a company and LLP, how would you say that the common corporate problems, say pertaining to operation mismanagement or partners dispute, can be addressed in case of an LLP, where there are no express jurisprudence available, unlike in case of companies? I think we have lost Chandrasekhar. So maybe by the time he comes back on, maybe we can move on to Santosh. And Santosh, we can sort of understand from you that, I mean, we know that in case of LLP, a lot depends on how comprehensively and well drafted the LLP agreement is. So in that case, what according to you are some of the important items that must be covered in an LLP agreement to deal with future contingencies if it may come to that?
Thanks, Prashant. Good evening, everyone. Having listened to our colleagues, now we know that LLP is a form of business model which is organized and largely operates on the basis of an agreement and provides flexibility without imposing detailed and the legal procedural requirements. Hence, a lot would depend on how comprehensively and a well-drafted LLP agreement is for the better conduct of the business. Hence, the drafted LLP agreement is more prone to pave many more ways and means to mismanagement, operation, dispute, etc. when the business operations grows exponentially. Having a well-drafted and a comprehensive LLP agreement is crucial for the smooth running of the business and also to avoid any, like a bumpy ride all the way. So now I would like to take you through some of the important clauses of the LLP agreement. So the must-have clauses in the LLP agreement from the perspective of good corporate governance. So I'm not touching upon all the standards in the LLP agreement. I'm touching upon only a few clauses which are very important from a perspective of corporate governance. Like my colleague Ankit mentioned, very distinction between an LLP and a company is that in a company there is a separation of ownership and a management, but in an LLP that is not there. So here the partners are the owners and then they are the managers. So LLP Act does not have any specific provision which deals with separation of management and ownership, but it is very important from a good corporate governance perspective to provide for such a separation of management and ownership. The LLP agreement as Act does not specifically provides for it. So unlike in a company form of business model, where the board of directors play the role of management and shareholders are the owners, in LLP partners play the dual role of management and owners, and sometimes it can turn out to be a vulnerable situation at times, and it can go beyond the partners and position. So basically, what is separation? What is separation of management and ownership? So separation is basically placing the management of the LLP under the responsibility of professionals who are not its owners and allowing the professionals with diverse skill sets to run the business. And it also enables the professionals to evaluate the business performance and point out areas of improvement, and then also it ensures a system which checks and balances is in place, and it conducts the business with smooth conduct. So that's the reason. So having separation of management ownership will really help the LLP conducting its business, and it gives enough clarity, enough transparency and accountability on the owners as well as the management of the LLP. So moving to the second important clause which every LLP agreement should have, separation of management and then periodical meetings capturing the proceedings of the decision making process. So basically, LLP agreement should provide for periodical meetings with the management or owners, say once in a quarter or once in a half a year, and capture those minutes of the meetings and have it signed in the records of the LLP, because these are very crucial from the point of view of in the court of law. Whenever there is a dispute arises, this can act as a very crucial evidences and can save the disputes in an easy way. So, and the Companies Act provides a detailed mechanics on how the governance should work, like how many times a company should, board of directors should, shareholder should, an annual general meeting, how the minute should be captured. Secretarial standards provides a detailed process on how the meeting should be conducted and how the minute should be signed and how the minute should be circulated to board members. Attendance register should be signed, and every director should attend at least one financial in a calendar year in a period of 12 months and all. So, but in case of LLP, there's absolutely nothing in the legislation which provides for all of this. Hence, it becomes very crucial to provide all of this in the LLP agreement, so that it also provides a good opportunity for interaction between the management and the owners to assess themselves, where they're heading, how the business is performing, and things like that. So in case of an LLP, so can even provide for physical presence of the partners or designated partners in a meeting, or they can even meet via video conference, and they can even adopt the mechanism of circular resolution for approving the decisions wherever physical presence or video conference is not possible. So and like some of the significant decisions like amendment to the LLP agreement, signing of financial statements, admission, retirement, removal of partners, designated partners, auditors, like purchase or sale of assets. So all the significant decisions should be taken at a meeting of the partners, and that actually gives enough clarity on how the business is conducted and what decisions are being taken at a meeting, and when that is captured and it proves to be a record and can be referred in the court of law whenever there is a dispute arises. So it is very important to have the meeting with partners and designated partners. So moving on to the next clause, related party transaction. Basically, related party transactions where conflict of interest is one significant thing. So whenever the LLP deals with related party transactions, say sale of goods or purchase of goods or services, so if there is any related party transaction, it is very important to keep the arm's length transaction with them, so that so there's absolutely no conflict of interest within the partners or among the stakeholders. So Companies Act provides a detailed provisions on how to deal with the related party transactions and what disclosure should be made and what kind of approvals should be obtained in case of such related party transactions and all. But LLP agreement does not provide for such provisions in case of if LLP wants to undertake any related party transactions. Hence, it is the best interest of the LLP and its partners to provide a detailed mechanism on how LLP should undertake the related party transaction. So details could be like what kinds of transactions can LLP undertake, the related parties, and who are the relatives that can be defined, and how the interest is defined. We can even define what is interest mean, and we can put certain thresholds on certain kind of transactions. So say if a transaction goes beyond certain thresholds, then we can say that we need certain kind of approvals, and we can even put restrictions on participation of interested partners in such transactions. We can provide for disclosures of such transaction before the meeting where the transactions are being put for voting. So these mechanics will definitely help in undertaking the related party transactions, and we can say that the transactions are arm's length and in the ordinary course of business. So moving on to the next one, so reserved matters. If you choose to go with the path of separation of management and ownership, so it is important to ensure that certain decisions are taken only with the consent of owners, some majority partner or a minority partner, whoever it is, basis the LLP agreement. So by having an agreed list of reserved matters, partners will have a chance to veto certain transactions if they feel they are going to be prejudicial to their contribution to the LLP. Right? So most items reserved are things which a management, which is so not an owner, which a management would otherwise have jurisdiction with reference to the owners. Hence, we need to strike a balance between the when we draft the list of reserved items, so that it should not create a hamper in the daily management of the LLP. So if you look at today's articles of associations, whenever there is an investment happens, the investor will always go for a reserved matter so that their investment is protected adequate. So they go for enough for like see reserved matters generally say that if a company wants to secure their assets for any of the loan and all, or if they want to borrow loans, or if they want to give guaranteed security, or if they want to bring additional capital, distribute dividends, or acquire or dispose assets, amendments to the charter documents and all. So those are the significant items where investors will put in on the will put them in under the category of reserved matters, and those reserved matters requires certain kind of approvals by certain kind of people. Because if you have such reserved matters also, the articles of association, separation of management and the owners, that we can strike a balance. We can distribute the among the management and the business. And another important borrowing investment. LLP Act does not provide for borrowings by the LLP. It does not have any specific provisions in connection with borrowing of monies or providing security, guarantees, making investments, etc. Right? In the absence of these provisions in the legislation, it's always better to have one couple of clauses connected with things where the agreement enables the partners to the and they can provide security, guarantee, or even make loans and investments in the LLP. Today, most of the banks and financial institutions, whenever the LLP approves or a financial company, so they generally exist for a LLP agreement, which is a clause saying that LLP can borrow, will invest, and all that. To have one clause on the LLP, which gives enough power and authority to the partners to borrow money and so make investments with security or guarantee, such kind of. Moving on to the next one, appointment of statutory auditors and conducting auditing books of accounts of the LLP. The LLP Act, provides mandatory appointment of auditors, certain kind of like when LLP is 40 lakhs, lakh or more, capital 5 lakh or such LLP should appoint auditors mandatory to get the books of accounts audited. But the crucial thing about audit is basically a very important checks and balance everyone should have, irrespective of whether the requirement of turnover or contribution. LLP should provide audit the accounts irrespective of the thresholds. LLP. Importance of audit cannot be overstated, right? So, and a good auditor can actually bring discipline, conduct of business, and at the grassroots level itself. Auditing of books of accounts will help in having a detailed how it's performing and compliance status of the firms. It actually generates the confidence of stakeholders and business customers, regulators, etc. And it also gives you an opportunity, gives the partners an opportunity to the cost and actually provides an accountability to the public. Hence, irrespective of the size and nature of the it is always good to have a mandatory appointment of an auditor in the LLP so that it and even that running. And one other clause, dispute resolution. So dispute resolution is basically a very important clause, and this generation every agreement, official contractor will have clause. Having a very comprehensive dispute resolution clause will actually like simple partners when there's a LLP agreement which is registered with the register of company, which is legally binding on all the parties to such agreement, should have a dispute resolution clause that future if the dispute happens, so that this can be addressed without of the and then even avoid expenses on such matter regulate. So it's obvious, right? So when two or more parties come together, business with intention to earn the profit, there's always a chance that the dispute. So dispute resolution clause actually lays out a resolution of such. Even today, there are few LLP agreements where we generally when such LLP agreements are entered among the family, they do not go to dispute resolution under that in nothing. But business run with an intention profits, that's there's a rule. Hence, having a well-drafted resolution clause not only avoid the parties from approaching tribunals, which is actually a tedious, time-consuming, costly affair, and it also involves public finance. So, the resolution clause will actually help parties in solving the disputes which the parties together. Some of the must have standard process like partners, the sharing show responsibility, liability, partners, and all. In addition to this, we can even have clauses like so. We're asking these questions. Yes, we can have those clauses in the LLP agreement. Provide such mechanism. Fine, not being. As a right, governance should stem from the culture and the mindset. It actually cannot be. And Martin Luther said morality can't be legislated, but it can be. With these words, I think I would like to continue and request Prashant to explain the factors considered in order to choose the suitable form of legal. Prashant, over.
Thank you. So now I'll come back again to Chandrashekar on the point that I was raising to him. So Chandrashekar, so Maulin discussed about the corporate governance framework standards for both companies and LLP, and he highlighted the fact that while there is established framework for companies which has been set out under the Companies Act as well, there are not prescribed standards of corporate governance for LLPs, and it is mostly agreement driven. Now, in light of that, where there are not enough jurisprudence available with respect to LLP, how do you think the common problems pertaining to these corporate vehicles, such as oppression mismanagement or disputes arising between the shareholders or the partners, may be addressed in case of an LLP, given the lack of jurisprudence on the subject with respect to LLPs? So maybe we'll come back to this topic subsequently. Now we'll move on to the next agenda that we had in mind, where we'd be touching upon certain other laws that sort of also play a role in determining as to which vehicle would be suitable for one's business. And one of the important laws in that regard is Foreign Exchange Management Act. And this specifically concerns those LLPs which have received foreign investments or which propose to receive foreign investment. Now, under Foreign Exchange Management Act, what becomes important is that while foreign investment is allowed in an LLP up to 100%, it is important that those LLPs must be engaged only in those activities in which 100% FDI is otherwise allowed under automatic route, and there are no FDI linked performance conditions. So it is essentially the nature of the business that would determine whether LLP can take FDI or it cannot. Now, what is the meaning of FDI linked performance conditions? That is a major roadblock when it comes to determining whether an LLP can take investments or not, because sometimes it may happen that the activities are such that 100% FDI is allowed in that, but because of there being FDI linked performance conditions, they are refrained from taking any foreign investments into them. These FDI linked performance conditions can be interpreted to mean those conditions which derive specifically out of the FDI policy or the non-debt instrument rules. And the reason why we say that, because these performance conditions get triggered only when you receive foreign investments. And so long as there are other conditions which say are also applicable on domestic players, it cannot be treated as foreign. It cannot be treated as FDI linked performance condition. To give you an example, say somebody wishes to set up a limited liability partnership for undertaking financial services. Now, under other financial services, 100% FDI is allowed, subject to adherence to the conditions that may have been prescribed by the sectoral regulators. Now, the fact that the conditions that the sectoral regulator may have prescribed would also be applicable on domestic players cannot be treated as FDI linked performance conditions, and therefore it is kept out of the purview of it. So while judging on which condition can be treated as FDI linked performance condition, one have to be mindful that those conditions must be deriving out of the FDI policy or the non-debt instrument rules. Now, the other aspect that sort of bothers a lot of investors while contemplating setting up a LLP is the valuation aspect associated with it. Now, when one plans to set up a new LLP entity, there is an upfront valuation that is required for one to be able to set up a LLP, while there is a specific exemption in that regard when one wishes to set up a company. So when you wish to subscribe to the shares of a company as part of the initial allotment, you are not required to produce any valuation certificate. Whereas if a contributor wants to contribute towards a LLP, in that case, the LLP would be required to obtain a valuation certificate pursuant to which the contribution would happen. And the same would also have to be produced at the time of reporting pertaining to those contributions. Now, other aspect about LLPs is the borrowings that it can take. Now, there are very limited scope of borrowings that LLP can take, which if you compare with a company is pretty much nothing, in the sense that the option of external commercial borrowing is not available to LLPs. Now, on this, there are divided views, and historically, it has always been that external commercial borrowing was never allowed for LLP. However, in a recent amendment that had happened to, a recent overhaul, I would say, that happened to ECB framework, all entities that were eligible to receive FDI were recognized as eligible borrowers. Now, by that logic, given that LLPs are also allowed to seek foreign investment, they should have also be treated as eligible borrower for the purposes of ECB. However, it was basically a question in the FAQ that the RBI had issued, where they had highlighted that LLPs are not eligible to take ECB, and even though that was subsequently updated and it was removed, but the AD banks are still of the view that even today RBI is of the view that LLPs are not eligible to take ECB, and therefore that position continues to be so. In terms of other borrowing that a company can make, if you compare the same with LLPs, the only option they have is to either take loan from their existing partners or to take loans from a banking company or financial institution. They don't have the kind of options company have in the form of debentures or bonds, and that is another limitation that is there with respect to LLPs. Then comes the aspect of the restructuring challenges that are there with respect to LLP. So as we know, with company, you have an option of merger, amalgamation, or demerger. Whereas with respect to LLP, when we talk about merger or amalgamation, that is only possible with another LLP. So the LLP Act provides for such merger to happen. But what happens when you intend to merge the LLP with another private limited company? Now, sometime back, the NCLT, the Chennai bench of NCLT had, in its ruling, sort of said that that sort of merger may also be possible. However, subsequently, that order was overturned by NCLAT, and it was said that the only possible way where a LLP can merge with a company is when the LLP opts for registering itself as a company, which is by way of conversion. So if the LLP converts itself into a private limited company, that's the only way for it to be merging with another merging it with another private limited company. Otherwise, in its LLP structure, it may not be able to merge.
So Prashant, yes, I can add one more thing.
Yes,
There was
Santosh.
only one instance. Yeah, there was only one instance where NCLT Chennai approved the scheme of amalgamation between an LLP and a company, right? So it was very surprising call by the Chennai NCLT, and it was appreciated by most of the industry people and all. Somehow, NCLT proved that it is not in the right of the text of the law or something like that, and they said that it is not actually right. They overturned the decision of the NCL, and that's the only instance today.
Now, moving on to the next point we have in terms of legal differentiation between LLPs and companies is with respect to raising capital. Now, as I said, the only form of capital that's available to an LLP other than the contribution is when it receives loan from its partners or from a bank or financial institution. When it comes to raising capital from public at large, there also LLP one it cannot go public because of the limitations of allowing only 20 partners who could make contributions to it, and therefore if again it has to raise capital from a larger section of investors, then it'll again have to convert itself and then opt for a public company, a public limited company structure, and then accordingly either follow the IPO route of raising capital or any other form of raising capital which is available to a company. So that, in a nutshell, even though LLP is a nascent structure and it has been evolving pretty well, but if you compare it with a company structure, there are so many other options that you have with a company which sort of is lacking with LLP. So the question that arises is, when is LLP a suitable structure for you, or when is company a suitable structure for you? A lot of it depends on what your business objectives are. If you are in a small scale business and you don't have clarity in terms of where you're going to be in the next 5 years, it is always an option that you start with a LLP structure where you have limited compliance, you have limited options as well, given that you don't have the clarity in terms of how you would want to go ahead with the business, and so that should be acceptable in those scenarios. And then depending upon how you evolve over the course of next few years, you always have an option to convert it into a private limited company and then continue it thereafter. But then if you are, for whatever reasons, in a business where it may not be feasible for you to have a LLP structure, in that case it is always best that you start with a private limited company structure. With that, I think, Chandrashekar, are you on?
Yes, Prashant.
Okay, great. So we'll come back to the question that we were trying to ask you, is that, and I think we have very limited time, so you'll probably have to wrap it up quickly. This question basically pertained to how there is lack of jurisprudence in terms of what could be the corporate governance standards for LLPs, and in light of that, how do you suggest that some of the corporate challenges pertaining to operational mismanagement or disputes between the partners may be addressed in case of an LLP?
Yeah, so quickly to discuss about a couple of practical challenges which the LLP will be exposed to in the absence of any strong corporate governance framework. Unless the partners of LLP choose to have a robust or comprehensive LLP agreement to put in place all the standards and processes to manage every aspects of business, the standard LLP prescribed under the LLP Act would be applicable, which is not a comprehensive document, and therefore it fails to provide practical guidance on any eventualities, and it would sometimes also mislead the partners. Then point number two, unlike a company, the LLP is not a legally required. LLP strictly is not legally required to comply with any specific requirements with respect to conducting periodical meetings of partner, disclosure and approval requirements for signing any related party transactions. There are no strict process to follow in terms of granting loans, guarantees, securities. So in the absence of these standards, then uh, 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 these standards may be adopted by the partners of a LP agreement only if they wish to follow them on a voluntary basis, but it's not something strictly required as far as LP is concerned. So while this approach of LP Act gives more flexibility, Practically, in many cases, the partners do not prefer to adopt those standards and end up signing a weak or a standard LLP agreement, due to which the corporate governance will be largely compromised. So, having said that, in order to keep the roots of transparency and governance intact, these standards should ideally be incorporated in the LLP agreement. So, some time ago, my colleague Santosh has explained a couple of mechanisms to be put in the LLP agreement so as to avoid any sort of conflict of interest and ensure that there are proper checks and balances in terms of compliance of LLP. Now, if you talk about audit requirements also, generally LLP is not required to undergo any internal secretarial or cost audits. Even in case of stat audit, only few of the LLPs are covered there, not all the LLPs. But while in case of company, almost all the companies are covered under stat audit, and internal cost audits and secretarial audits are also applicable for most of the companies whenever they exceed any thresholds. So, in the absence of any independent check on financial dealings of a LLP fails to get a better access to funding from banks and financial institutions when it comes to as compared to a company. Also, when it comes to charges, right, creation of charges under the LLP Act, it's not a mandatory requirement to create the charges. So, which is again, it's not desirable as far as when you're raising a secured loan from banks or financial institutions. Now, if you talk about other remedies which are available generally in case of a company like operation mismanagement, there is a redressal mechanism for operational mismanagement. Whereas in case of a company, there are no elaborate framework. In the absence of any such mechanisms in the LLP, there could be higher cases of mismanagement of affairs or operation of minority interest. And in such case, there is no legal remedy available for minority partners except quitting the firm itself. Now, if you talk about other challenges in the absence of a strong framework of governance in LP, the partners are generally prone to mismanagement of affairs, irresponsibility, lack of discipline in their approach, conflict of interest issues, and also internal disputes. Lastly, in case of 50-50 LLP structure, right, wherein both the partners hold equal stake and rights, and in such cases, unless there is a comprehensive and carefully drafted LLP agreement in place, such LLPs are more prone to deadlock situations on account of difference of views among the partners on many aspects, having no clarity on roles and responsibilities of each partners and things like that. So common issues which would broadly arise when the corporate governance get compromised in a firm are conflict of interest, issues in terms of oversight, accountability, transparency, and violation of ethics. One last point to and I'll wind up. So one is comparatively also LLP structure got a legal recognition in India only in 2009. It's relatively a newer concept, and even after a decade of its existence, I would say it's still at a nascent stage in India. There are hardly any practical cases or judgments in India which can give a clarity on various aspects of LLP structure, especially in cases of disputes among partners, operation mismanagement, protection of interest of partners. Whereas on the other hand, LP has a company business model has been in existence since many decades. It is a well-established jurisprudence, processes, and procedures established in India, which gives a lot of confidence and guidance for entrepreneurs to run a business model in form of a company. Now, question would arise whether LP can be structured in a way to increase the corporate governance, like in case of a company. Well, the answer is yes. Although LP lacks governance-related regulations in the LP Act, it is possible to increase the governance by providing a detailed mechanism in the LP agreement itself. So my colleague Santosh has already touched upon those areas, and he has explained briefly what are the key mechanisms to be provided in the LP agreement. So with this, over to you, Prashant. Thank you.
Thank you, Chandrashekar. We are anyway out of time, and I really want to apologize for not being able to answer to a lot of questions that have actually come in the chat box. While we have been trying our best to respond to most of them in the chat box itself, the ones that we have not been able to address, we will try and respond to you by responding to those on your respective email IDs. Before we end our session, there's one last question that I wanted to take. This is a question from Vimal. And Vimal asks us that there was some confusion with respect to sectors/objects, example, manufacturing, for which the LLP can be incorporated or not. So now, with respect to this part, yes, there was a circular that was issued by MCA that LLP structures should not be acceptable for manufacturing purposes. But then soon thereafter, after a lot of parties sort of made representation to MCA with respect to that, they had, recalled that office memorandum that they had issued. So now the position on that is clear, that LLPs can also be set up for manufacturing purposes. And the second part of your question is trust all sectors where FDI is allowed in company it is also allowed in LLP, or there are any specific consideration with respect to FDI. So with respect to that, as I said, I mean, so long as 100% FDI is allowed in those sectors or activities up to 100%, and there are no other FDI linked performance condition, then LLP is good to make. LLP is good to carry on those activities and also receive foreign investments for the purpose of that business. I think with that, we will now conclude our session.